0516-PET, petition of Otter Creek Solar LLC requesting a certificate of public good pursuant to 30 VSA Section 248, authorizing the installation and operation of a 2.2 megawatt solar electric generation facility in Bennington, Vermont. My name is Anthony Roisman, and I'll be the hearing officer for this case. I'd like to start with appearances for the petitioner.
Michael Malone on behalf of Otter Creek Solar LLC.
And do I understand that Thomas Malone is on the phone?
He is.
Yes, good morning, Mr. Chairman. Tom Malone on the phone for the petitioner as well.
All right. And which one of you will be speaking on behalf of the petitioner?
I will.
Okay, thank you. For the department?
I'm sorry, is Tom, was that Tom speaking?
Michael Malone.
Yes.
Okay, Michael, okay.
And just for everyone's purposes, the court reporter is also on the phone, so unless you have an extraordinarily distinctive voice, Mr. Porter, for example, will be well recognized. His Vermont accent is distinctive. But please identify yourself, and I'll get to those of you on the phone so we can get your names in the record. But I'm going to go through the people here in the room. So the department?
Megan Ledwig for the Department of Public Service.
Jim Porter with the Department of Public Service.
Allison Milbury Stone for the Agency of Agriculture.
Don Einhorn on behalf of Natural Resources Agency.
Okay. And now on the telephone, Mr. Malone has already identified himself. Who else is on the phone? And please identify yourself and the party or potential party that you represent. Anyone else? All right. Others might be joining us. I've been given notice that Representative Mary Morrissey of Bennington has indicated that she was going to be on the phone, but also that the demands of the legislature today, she might not be on at exactly the same time as we're starting. Okay. Are the Agency of Agriculture and the HD Natural Resources intending to be active participants in the proceeding at this point?
At this point, yes.
All right, and of agriculture?
We've already reached an agreement with the petitioner, so I guess not particularly active. Yeah.
So you've come for the show, but not to participate. Okay, that's fine. I just want to sort of get an idea of how many players we're going to have. And who will be taking the lead for the department?
I will be one of the counsel on the case, and Allison Winnup will also be with me. She's not in the office today, but we'll be sharing responsibility.
Okay. And as I made clear in the procedural order, each party will have a single representative with regard to any issue. So there'll be no multiple people speaking to the same issue. I don't care if you've got 10 people and each one takes one of 10 issues, but to the extent that we have interveners in the case, the same thing will be true. Petitioner, the same thing will be true, so that we try to move the proceeding as efficiently as possible. I wanted to say in a preliminary way just a little bit about demeanor. Some of these cases, and surprisingly, they all seem to be in Bennington, have raised a lot of controversy. And frankly, I think that's good. To me, it is the best part of the legal process if people whose interests may be affected are actively involved. But active doesn't mean in any way disrespectful of the process or of the parties. So I am hopeful that everyone will conduct themselves like grown-ups. And should that not occur, I will not be reluctant to let people know that that is unacceptable. playing well with others is very important. As a former litigator, I am keenly aware of the temptation to not always do that. But having been there, I understand. One of the things that I have indicated in the order that I issued on the 3rd of May is that before a dispute reaches here, the parties must consult. And if the result of that consultation is that there's a motion has to be filed, the motion needs to indicate that a consultation has occurred. And I would expect that when that occurs, the parties who are in dispute and haven't been able to resolve it will also propose a schedule for the resolution of that particular dispute, so that we don't have to have a separate process by which we try to figure out, well, how long will the party who is opposing have an opportunity to oppose, and will there be an opportunity for a reply, and how long for that? I'd like all that to get wrapped up so that we can move things along efficiently on all of these issues. And I appreciate, Mr. Malone, your references to Willie Tomlin. I like those kinds of references. And the reference that I'm particularly fond of is what the captain said in Cool Hand Luke to Luke when he looked down at him and said, what we have here is a failure to communicate. I want to make sure that we have as little of that as possible here. So please, talk to each other. I'm not saying you've got to resolve all your differences. They will be there. But let's make sure that we fight over the things that need to be fought over and resolve the things that need to be resolved. And in that vein, the Commission has started a process by which we look to see cases that might lend themselves either to the use of a facilitator, someone to sort of help the parties get their positions clarified, make sure that we know what they really want to fight about, and make sure that that's what they focus on, and also to mediate. And while mediation is normally thought of as a way of resolving an entire case, it's also a way of resolving issues inside a case. The recent filing between the Department of Agriculture and the petitioner is a perfect example of that. So, one, if for any reason the parties feel that it would be helpful to have a facilitator, another hearing officer who would not communicate with me in any way during this proceeding could sit down with the parties and see if you could, with the help of the facilitator, frame issues more clearly, move the process along more efficiently, and make everything work better. And if you think there are things that could actually be mediated, an issue that might arise where mediation would work, that hearing officer can then facilitate getting a mediator involved in the process and see if we can mediate. That's completely up to you. Failure to do it is not a black mark against anybody, and I would know nothing of the process other than if there was a result, you would let me know. We disagreed about X, we've worked out our differences, and here's what we want to do. So please keep an open mind about using that if that will help. We have this motion for a stay that's currently pending, and I'll get to that in a minute, but regardless of what we might decide on the question of the stay, I want to make clear that I believe that at this moment, the discovery process is open, and a round of discovery can begin at any time. Once we resolve the stay question, we can then also decide when that round of discovery will end. So I encourage those of you who are parties, and to the extent that there are ultimately interveners in the case, I will encourage them to start any discovery that you've got as early as possible. And I know the normal practice has been that we talk about rounds of discovery, and that implies that you get on a date certain, or but not after that date. The ability to ask some questions or seek some documents. I encourage you all to sort of just relax and share information if you've got it with the other parties, and facilitate moving that along. Once we decide the stay issue, we'll then decide what to do with the remainder of the schedule. We'll have a second round of discovery after the pre-filed testimony comes in from all the non-petitioner parties, and we'll have a third round after, if there is rebuttal testimony filed by the petitioner, after the rebuttal testimony is filed. And I'll be open to another round of discovery if the parties think that that's useful, but for the moment, I don't anticipate that we have more than those rounds of discovery. I appreciate everyone coming forward with a agreed date for the site visit. Events intervened that made that impossible. My clerk's office advises me that we need 2 weeks from the date that we actually know when we're going to have the site visit and the public hearing to get something published in the paper and meet the statutory requirement of advance notice. I've also looked at my schedule. I have 2 dates that are possible, the earliest of which is the 11th of June for a site visit and a public hearing, and the other is the 20th of June. If it's the 11th of June that you all agree to, we need to know before the end of the day today the actual location, so that we can get that information to the newspaper in Bennington. It turns out that their schedule is somewhat extended when there's a holiday, because they expect some of their staff to not only take off the holiday, which is next Monday, but some of the days afterwards. So we would need to know today if you want to do it on the 11th. The next available date is the 20th of June. Once we've resolved any petitions to intervene, and that will occur once we get a better picture of what we're going to do on the stay question, then we will have all of you converse, parties now, any interveners who admitted, and we'll respond to the full set of items identified in the May 3rd order with regard to scheduling. What are you proposing for those different things? Now let's talk about this stay motion. We're not going to decide it today.
So Mr. Porter and I had a chance to speak before this hearing started, and I think we came to a resolution, and I'll let Mr. Porter speak to that.
So I think generally we've resolved the issue over the necessity and the reasonableness of our hiring an aesthetics person. We will, assuming that's the case, we will withdraw our motion for a stay, and we had talked about our problem right now is contracts with aesthetics people. We have contracts pending that should come in within the next week. So we had talked about a site visit 2 weeks after June 4th, so we would have an expert on board. So I guess with the 20th, that works for us.
All right. And the agency, you usually like to have someone at a site visit. Will the 20th work for you?
20th works for me. We generally don't have our technical staff at commission site visits because the issues that they deal with at a site visit take many hours sometimes, and
Okay.
so.
All right, well, that's fine.
But
I mean,
occasionally we
obviously,
will. I don't anticipate the need for that here.
Obviously, they're welcome. And then in discussions with the applicant, go back as often as you like. All right. And agriculture, I assume, if your issues are taken care of, unless you just wanna go to Bennington, it's a lovely town.
Yeah, I don't anticipate that we would attend, but in any event, wouldn't have any objection to the 20th.
All right, so we will set,
I'm sorry, excuse me, I didn't hear what Ms. Stone said.
I said that I didn't anticipate that the agency would attend, but in any event, that the 20th, we had no objection to that particular date.
good, okay,
Thank you.
so the public hearing will be on the 20th. The deadline for petitions to intervene will then be the 27th. And, Mr. Malone, do you want me to just set the normal time for response to petitions to intervene, or would you be comfortable with less time, or do you want to wait and see how many petitions there are and what their bases are? How would you like to proceed?
I think we would be comfortable with a less amount of time to respond.
Okay, so you want to give me an idea?
Uh,
Assuming we get them on the 27th, that'll be the deadline for petitions to intervene.
Say 7 days.
Okay, all right. So that'll be the 34th, which I guess means that's the 4th of July. That's very, very generous of you, but I assume you'd like the 5th of July?
That's my birthday. So.
Oh, well then, I know you want the 5th, right?
Whatever.
All right. Okay, perfect. All right. Now, what you did on the stay, I want to see a lot more of that. That's good.
And we appreciate your offer for a facilitator in the event that we have other disputes, and we will certainly take you up on that offer if that comes to fruition. But we're hoping to, the reason for, we submitted the motion quite urgently because we saw the site visit coming up and we wanted to make sure that, we weren't caught without any assistance at the site visit, so,
You're gonna need to speak up.
I'm
even
sorry.
I'm having a little
I'm
trouble
sorry.
hearing you.
But we will make sure to consult well in advance if other issues arise during the proceeding. But we are happy we had an opportunity to consult before the hearing conference.
Okay. All right, so under those circumstances, then we have what you all had originally agreed to the day before the stay request was filed, to a scheduling. The pre-hearing conference is still set, the site visit has changed, the motions to intervene have changed, response to motions to intervene will have changed. And then you've got these two options of no issues following the site visit, one approach, and if there are issues, then you will come in with a new schedule. And that makes perfectly good sense to me. And as long as, at this point, when you say no issues following the site visit, I assume that what you're basically saying is that don't be an intervention beyond the parties who are already identified. And so let me just be clear that both A&R and the department are comfortable with, it looks like, 2 weeks. Well, it's a month after the public hearing that, so it would be July the 20th, that you would have pre-filed, assuming that there were no interventions.
Yes, so we would move that July 2nd date to the 20th.
Okay.
Yes, we would be comfortable with that.
And just so I'm clear, all of you, when it says if no issues following the site visit, does that mean if no party disagrees with the position of the petitioner?
Yes, we believe if we
Okay.
have resolved any of the department's issues with the petitioner following the site visit, then we will provide notification to the commission that we have no other issues with this section 248 criteria.
Okay, all right. And that, Is that equally true?
No other issues with, I'm sorry.
Under the
No other
section-
issues with what?
I'm sorry, Kim, under the section 248 criteria.
Thank you.
The agency's understanding is a little different. So if there are no issues, there would not be any testimony typically from the agency. So I think the non-petitioner direct was intended to be the department's testimony if issues were resolved, because the practice most recently is the department doesn't enter into stipulations and instead sometimes puts in testimony even if they're not opposing the petition. The agency doesn't do that. If issues are resolved, we would have reached a stipulation or determined that as proposed, as modified as proposed, there's no undue adverse impact under B5 to the natural environment. So I didn't view that as the agency putting in testimony. The agency would put in testimony if it bumped to a litigation track and we have submitted a schedule at that point for a contested case proceeding.
Okay, and I wasn't really focused on whether someone would or wouldn't be providing testimony. I just wanted to make sure I understood what it meant, if no issues. And what it means is that no party at that point will have determined that they had a disagreement with the applicant on anything that hadn't been resolved. Otherwise, we go to phase 2, the alternative approach. Okay.
Correct.
Mr. Malone, is that consistent with your understanding?
That's consistent, and I just wanted to point out July 20th is a Saturday.
Okay. Department working on Saturdays?
Some of us.
Okay, so that will be the following Monday? July
22nd? No, yes, 22nd.
All right. Lastly, unless you all have some other issues, in my order of May 3rd, I identified 4 items that I was intending to follow in this proceeding and invited if any of you had any concerns with those ideas to let me know about them now. There, you start on page 2. Either concerns or questions, what is it that I mean by that? Because I think none of them are currently standard practice in most of our hearings. So I thought it would be fair to let you say, wow, that's a bad idea, or I don't understand it, or both.
I'm sorry, Mr. Weissman, can you speak up a little bit, please?
I think that's the first time anyone's ever said that to me, but yes. Here, I'm using the microphone now. Is that better?
Yes, it is, thank you.
Okay, sure. By the way, has anybody new joined the phone conference? All right, good, thank you. All right, so did Mr. Malone or Mr. Porter, any concerns with those? It looks like you all are looking at them for the first time. That's okay. You can let me know later. We have a little time. I just thought since we're all here today, if you wanted to discuss it or make sure you understood what I was saying. If you're reading it for the first time, I'm not going to ask you to do anything. You can send me something. Just send something in. By the way, just so you know, I'm not much of a fan of filing letters with the clerk's office that are substantive. If you have something substantive to say, send it as a filing under other documents in the EPUC, and you can title it anything you want. Information request, or response to information inquiry, or It doesn't have to be a motion, but it's always struck me as strange that someone files something very substantive, they do it in a letter, it's addressed to the clerk. I find this true of courts as well. And everybody knows the clerk is not the one who's going to respond to it. Why do you write them and ask them to respond? Anyway, so you're welcome to do that later. If you have nothing to say about it now or ask about it now, that's fine. Mr. Ryan?
I don't,
Mr. Moe?
No.
No? Great. Okay. Anything that you all want to talk about?
I have a general question or question
Okay.
and comment perhaps, unrelated to this matter specifically. One of the things you mentioned and the agency certainly supports, and we do this commonly, is what we call informal discovery and not await formal rounds of discovery. And we find that to be very useful. So that's something that we typically avail ourselves to. The question I have is about the facilitator and mediator. As you know, in these types of 248 proceedings, oftentimes a full schedule, what I'll call litigation schedule, for lack of a better term, is agreed to and put in place at the beginning of the proceeding after the pre-hearing conference scheduling order. And there are, oftentimes it's challenging, I know for the agency, and I understand for the department sometimes, to turn around and meet the deadlines on some of those milestones, if you would. And we always try to work, it's always a compromise. Give us enough time to respond to discovery or to prepare, rebuttal testimony or whatever it is. How do you envision, if there's a need to bring in a facilitator, if a party asks to bring in a facilitator or even a mediator from the commission, how does that interplay with a schedule that's in place, kind of locked in place? Because a facilitation or kind of a side mediation process could obviously take some time if the parties are truly engaged in trying to work through an issue, and it's hard to do that. Well, you also have a pending deadline, perhaps, for responding to discovery or filing testimony. I'm just curious. It's more of a general question.
Okay, good. That's a good question. Thank you. My inclination is, first of all, if the parties agree to something and everybody agrees, I'm going to agree. My view of this is that while the commission obviously has independent obligations substantively, we have to evaluate issues even if none of you get involved in them, and we may ask questions that none of you ask. Other than that, if the parties agree, so let's say you have the situation that you described. There's a schedule, the schedule says something's to be done by a certain date, and before that date, something comes up that's going to involve you being involved in facilitation or maybe doing a site visit or whatever it might be. And the parties agree that they're fine with essentially staying everything that's going on at that moment until that process is completed. I'm going to say fine. I'm certainly not going to say to you, oh, I don't care that all of you want to change it, I'm not letting you change it. That will not happen. Even in a situation where there is a scheduling date coming up and there's not an agreement to postpone the date, I'm not going to be inclined to use the fact, well, we previously agreed to that date, to refuse to allow a reasonable request to move that date to be granted. However, I'm expecting that when people want the schedule changed, they will be asking for the change as early as they need to. An order was issued either yesterday or will be issued today in a case called Solar Sense. And it's a request for a waiver of a statutory provision regarding when a particular CPG had to be used. And I won't go into the details of it, but you will see I've written a dissent in that case, and the basis for my dissent is that I do not believe that a good cause was shown for failing to timely file the request that is the subject of the case. I'm sort of a stickler about that. So, you know, showing up the day before a deadline and saying, 3 weeks ago, X happened and I'm not gonna be able to meet this deadline, I want to change it, is not likely to be looked upon with much favor. By the same token, if you really have a good cause to change a date, at least right now, I would expect that all of you would be able to persuade the other that you have a good cause and the other should be reasonable about it. When I was doing litigation, my attitude was always, I would give my other side the benefit of the doubt. They said they needed an extension, I would give them an extension. The first time they told me that I couldn't get an extension, I changed my attitude. So if everybody plays nice with everybody, I don't think your problem should arise. And if the petitioner or the department, or any intervener for that matter, is comfortable with exchanging information without the formality of discovery or discovery deadlines, that's great. I mean, these deadlines are only there so that everybody knows that if people want the process to stop, there's a date by which that process stops. Okay?
Thank you, that's
Yeah.
helpful.
All right, well, if there's nothing else, thank you all very much. I'm sorry we couldn't bring you spring. Mr. Malone, when you come north, I assume you expect nice spring-like weather. We're promised that in June it should show up. I look forward to dealing with all of you during the case, and thanks.
Actually,
Yes.
I was looking at the May 3rd order, and I just had a question about, a clarifying question about what was intended with respect to intervenor participation. It says intervenors who establish standing will be admitted on all issues for purposes of discovery, but their participation at the hearing will be limited to issues in which they pre-file testimony or pre-file demonstration of areas of cross-examination that are relevant and non-redundant.
Right.
So if somebody established they had an interest with respect to aesthetics, then they could serve discovery regarding any issues.
That
If they
is
had questions on prime ag soils, and then their participation at the hearing, I'm trying to understand what, it's limited to issues on which they pre-filed testimony. Is that related to what their initial interest was, or
No.
they can pre-file testimony on
Anything.
Okay.
Just so you understand, my thinking is that it's quite possible that a party, even an already statutory party, might not, until discovery is taking place, realize that they have a concern with subject X. Certainly applies to an intervener. So if they do general discovery within the limits, and that you'll notice point 2 is the new federal and Vermont rules that restrict the use of discovery unless the balance is good, you know, asking someone for a huge amount of information that has only a very tiny marginal benefit, not to be allowed. And there has to be consultation and all those other restrictions. But the discovery may help someone who intervened understand what issues they want to follow. Current procedure has usually been, in that case, the intervener originally got admitted only on issues 1 and 2. Now discovery shows that they think they've got a legitimate interest on issue 3. They have to file a motion, there has to be a reply, there has to be a response, there has to be a decision that they can now also participate on issue 3. And so what this is saying is they can do discovery on everything, which is the way it happens in the federal court. Once you intervene in a case, you're in for everything. The time when their restriction applies is the time when they really become a critical path item, i.e. at the evidentiary hearing. So under this process, I would expect that a party that wants to do cross-examination would have had to demonstrate in advance some reason to believe that their cross-examination is substantively based.
Thank you.
Mr. Porter, you look either puzzled or?
I live puzzled. I think that makes it work.
Okay. All right. It is new, and that's why I called it out that way. For the moment, it doesn't matter because we technically don't have any intervener in the case other than the state agencies, but that could very well change. All right? Oh, and there's one other thing. If we get interveners in the case who are not represented by counsel, which is certainly possible, I would like to be able to advise them that if they have procedural questions, that the public advocate will help them understand procedures, obviously not substantive, not helping prepare their case or anything like that, but just to be able to say, well, here's what it means when it says you've got to do X.
We do that, and we're happy to.
Good.
do that.
I thought that was the case. All right, if there's nothing else, thank you. Thank you, Mr. Malone, for being on the phone, Kim, for being wherever you are. And this pre-hearing scheduling conference is adjourned, and unless I hear differently, I'm going to assume the stay issue is resolved.
It is, and we'll follow withdrawal.
Good, okay, perfect. And I'll see you all on the 20th in Bennington. And Mr. Malone, will you please make sure that you not only found the place you want to have the public hearing, but identify where you want people who are coming to the site visit to assemble for purposes of going to the site visit.
Will do.
All right, great. Thank you all.
Thank you.
So I'm glad to see there's some dissents. It's been a long time. Makes it a little more
Thank you.
interesting.
It was a hard-fought battle. I'm channeling John Burke.
I wasn't going to say that, but I was thinking it.
Thank you all.
See ya. Thank y'all. Bye, Michael. Thanks.
See ya.